So, to our presenters, I want to say thank you. The papers you are sharing today are the results of sustained thought, careful research, and scholarly commitments. We recognize the effort behind each submission, and we are honored that you have chosen this platform to share your work. To our participants, welcome. I encourage you to engage fully with what is presented today. Ask questions, push the ideas. The value of this symposium is not just in the papers themselves, but in the conversations that they will generate. And to the editorial team, your work made this possible. The process of bringing a publication to life is not simple. And yes, you saw it with vigor and dedication. We are very grateful. And lastly, to Kélicia, our managing editor, thank you for your leadership. This inaugural edition exists because of your commitment to seeing it done and done well. So we have a full program ahead, and I am confident that it will be worth every minute of your time. Once again, welcome, and let's begin.
Good morning, everyone. Thank you, Grace. Good morning, everyone, and welcome to session 1. I think we can start with session 1 of the Inaugural Publication Symposium of the Journal of African Fashion Law, Policy and Innovation. My name is Kélicia Massala, and I have the pleasure of serving as chair for this session and as managing editor of the journal, like Grace said. So this first session, titled Foundations, Frameworks, and the Informal Economy, is intentionally placed at the beginning of today's program because it addresses some of the most fundamental questions facing the field. So what fashion law means in the African context and what kind of legal structures currently shape the industry and where those structures fall short and how long can law become more responsive to how law can actually become more responsive to the realities of African fashion markets. So one of the strongest things about the papers we've gathered in this session is that they do not treat fashion law as a narrow or important concept. They actually treat it as a living and evolving field, one that must be read through African markets, African institutions, African production system, and African legal realities. Across these 5 papers that we will hear about at the first session, we move from definition and field building to doctrinal critique, to digital governance, to dispute and resolution under the AFCFTA, and finally to the structural misalignment between formal intellectual property systems and informal fashion economies that we can face in the African markets. So together, these papers do something very important because they help us move beyond the idea that the legal issues facing African fashion are merely incidental. Instead, they show that the field already has its own vocabulary, its own tensions, its own institutional questions, and increasingly its own scholarly foundation. The paper also reminds us that African fashion law cannot be built only around abstract rights. It has to engage with the actual condition under which fashion is produced, circulated, copied, protected, traded, digitized, and contested across the continent. That means engaging with informality, with regional fragmentation, with questions of access, with platform governance, and with the need for legal tools that are both intellectually rigorous and practically usable. So this first session is really about foundations in the fullest sense. So conceptual foundations, doctrinal foundations, institutional foundation, and commercial foundations. We will hear 5 presentations, each allotted 10 minutes. and then we will have a moderated Q&A at the end of the session. I will ask all speakers as gently as possible to keep closely to time so that we can preserve space for discussion at the end of the session. So with that, let us begin with our first paper. So our first paper is titled Defining Fashion Law in Africa, Scope, Foundations, and Future Directions. This article opens the issue very fittingly because it gives us a vocabulary for the field itself. It argues that fashion law in Africa should be treated not simply as an extension of intellectual property law, but as a distinct multidisciplinary field shaped by commerce, labor, trade, sustainability, consumer law, cultural heritage, and regional integration. So it is my pleasure to invite Bernice Asein, the editor-in-chief of the journal and the founder of the Fashion Law Institute, to present paper number 1.
Hello, everyone. Can you hear me?
Yes, we can hear you.
Okay, let me try to share my screen. Ellie, can you see my screen now?
Yes, we can see you.
Yes.
Okay. Can you see my slide?
Yes.
Not yet.
Okay. Now, can you see?
No, I can't see on my end.
Well, sorry. Excuse.
I think that when you try to share your screen, they might ask you which window you want. And so you have to click on the window that has the presentation in it and not the Zoom window. Let's try this. I don't know if it's going to work. Yes, perfect. We can see it. I think you can put it on as a Dapo, a presentation, and yeah. Okay, perfect. You can start, Bernice.
Yes. Okay. Good morning, everyone. My name is Bernice, and I'm the founder of the Fashion Law Institute.
The mic. We might have a hard time to hear you. Yeah, I think the mic cut off.
Okay, can you hear me now?
Yeah, you can start over. It's fine.
Can you hear me now?
Yeah. Yes. No, it went
Okay.
again.
In the journal.
Oh. Try to speak now.
Hello.
Okay, now we
Can you
can
hear
hear.
me?
Yeah, now we can.
It's
Okay.
better now.
Okay. Can you hear me?
Yes.
Okay, so one of the reasons why we decided to include this particular paper, Defining Fashion Law, was because this is going to be our very first journal, and it was important to set the foundation as to what fashion law is. I know that a lot of us really are new in the space, and there is the idea that fashion law is very niche, it's limited to intellectual property law. It doesn't really have other areas of law intersecting. So one of the things that my paper does is really addressing the legal issues that exist in the fashion industry. The fashion industry is worth over $30 billion. So how many jobs it's going to produce in the next year. We have a lot of conversation about how that it can employ a vast majority of people and creators across the continent. However, when you think about the potential of this industry, you would see that why the numbers are very, very extensive legal framework that supports this expansion. And you would see in my interaction really and in my work, you'd see that one of the problems that we see is that there is cost on the fashion industry to support the expansion of the industry. You would see that when you look at the entire value chain of the fashion industry, from fiber to fashion, and what I mean by that is that you're looking at the farmers, you're looking at the raw materials, some this raw materials into finished products, and then the retail aspect of it. You would see that there are a lot of laws that actually play, but are not peculiarly looking at the uniqueness of the fashion industry. So my paper touches on all of this area, giving our readers more of a diverse and economic context to the fashion industry. Because once you're able to understand the entire value chain of the fashion industry, you would see that there are multiple legal frameworks. To say is that really it's not even fashion law, it's fashion laws, because we can identify over 30 frameworks that can intersect the fashion industry when you look at the entire value chain. So it's very important that we had this paper included. And one of the things that we also try to do that fashion is really not about intellectual property alone. Intellectual property forms a major part of the fashion industry. But when you work with formal and informal economies, you would see that there are various areas that you have to deal with. For example, when you look at fashion law, generate creativity. It is something that is communally owned by a group of people, not just one person. And when you look at the extant framework of intellectual property, you would see that it is very individualistic in nature. It's looking at one author, one person that generates this idea. But in the African context, most of the things that we refer to as our creativity are cultural heritages that belongs to a community of people, right? So we tend to say that yes, intellectual property is part of it, but it's also cultural property. There's also commercial contracts. I mentioned earlier that there's the entire value chain that you have to look at, from the raw materials to the after. You would know that there's a lot of business transactions and agreement that is entered into by the players of this industry. So it's very important that you also understand that aspect, and that's what we try to demystify in my paper. And there's also labor laws, right? The fashion industry is one of the guys to the level that we are projecting that it gets to. So you have to start thinking about factories, manufacturing, and industrialization. And in doing that, you would know that the people who help with these industries, the people who would help with manufacturing, are at the core. They have to be protected, right? And when you also talk about sustainability, human beings, the people, are also part of that, ensure the rights and protection of fashion workers in the industry. Another aspect that we looked at is why this paper is necessary, is to identify the very fact that we operate in an informal economy. So there's need for sensitized and the proper channels of registration and protection, right? So it's important at the initial stage for us to sensitize people on what we are doing in the fashion and policy space. There's also the very fact that there are a lot of laws, like I mentioned before, that exist, right? Other laws that you can think about. And one of the things that I identified in the book that I wrote, Fashion Law in Africa, it was identifying all of the intersection of law in the fashion industry. And there were over 30, right, that applies to the fashion industry. And every single day, you would see that as the industry is growing, other areas also intersect. So that particular frameworks, those things that you identify at play, that we have to look at. There's also the very fact that there is defective enforcement. I mean, in practice, one of the problems that I have encountered is, looking at the particular brand and saying that this particular thing can be enforceable, and the fashion industry is very nuanced. So, and you would see that there are even no precedents, right? So that particular fact that there are laws, but you can't enforce them. You look at the capacity for people to believe that this particular product enjoys intellectual property laws. So those are the things that are faced by the fashion industry that in my paper I tried to highlight. Now, there's also the aspect of the future direction. We see that every now and then there's conversations about artificial intelligence and how it is changing the space, and of the area of law that is affected largely by technology. You're looking at AI and digital fashion. How do you say that a design that is generated by someone, how do you determine authorship in copyright? How do you determine who owns what is sufficient that you have expended your human power to make something original? We do not currently have laws that speak to that. Who really owns these things? There's also the very that there is cross-border trade happening, a lot of transactions, a lot of e-commerce platforms are coming up, relations that you have to think about. You particular scale. So those are issues that I will really part of the things that we have to consider in the near future. And there's also sustainability, right? Sustainability is a very important aspect of the fashion industry, because the fashion industry is generate a lot of waste, and there's a lot of conversation around waste colonialism. How do we manage waste? How do we run a secular African fashion market? Because you see that a lot of people who play in the African fashion market export their products to very regulated continents. So how do we manage that? And those are the areas that I also try to talk about in my paper. So yes, I think that I've come to the end of my presentation. The fashion law in the fashion industry has to be recognized also as an independent area of law. And it's one of the things that I also talked about, because one of the struggles we have is people seeing this as a discipline that they can actually focus on. But in this paper, I try to identify why it is, right? How we can focus on local context and the economic reality, and also the cultural significance of fashion law. It's really not just about intellectual property alone, but there are other areas of law that helps make fashion law, especially African fashion law, very, very unique. So yeah, with all of fashion law in the African context. Thank you so much for listening.
Thank you very much, Bernice, for that thoughtful and field-setting presentation. we really needed it at the beginning. So it's great to set the tone.
Yeah, thank you.
You're welcome.
I'll stop.
Our second paper is titled The Regulatory Paradox, Structural Defects of Certification Trademarks in the Protection of Nigerian Indigenous Textiles. So this is one of the most doctrinally precise papers in the issue. It examines how the current certification mark regime in Nigeria can paradoxically exclude the very artisan communities it is supposed to protect. And it proposes a reform path through comparative analysis involving OAPI, Kenya, and Ghana. So I am pleased to invite Praise Adegoke to present paper number 2.
Hello, Kélicia. Can you hear me?
Yeah.
Yeah, so this particular paper will be moved to later. He sent an email saying that he would be late to join, so we can just move to the next one. Yeah, the
Okay.
person. Yeah.
Okay, good. So our second paper then will be Data Privacy and AI Governance in Africa's Digital Fashion Ecosystem. And this paper brings an important digital governance lens into the session. So it examines what happens when African fashion becomes increasingly mediated by e-commerce, AI-driven personalization, virtual reality tools, and platform infrastructures. And the paper also asks whether current regulatory frameworks are actually equipped to protect consumers and markets in that environment. So please join me in welcoming Dapo Agboola for paper number 2.
Yeah. Hi, good morning, everyone. Can you hear me?
Yes.
Okay. Let me try to get my slides up. Sorry, please just.
Bernice, is Dapo having an issue with this presentation?
Yes, he is. Yes, he is. I don't know if we can wait for him, so we'll just
We can
move to
wait
the
because we're actually ahead of our program. We can wait a little bit.
Okay, we'll just give him 2
5
minutes.
Yeah, okay.
Yeah, good morning, everyone.
Good morning, Dapo. Welcome back.
Yeah, thank you. And I'm sorry for that interruption.
No worries.
Yeah, firstly, I would like to say a big thank you to the organization for the opportunity to present this paper. It's a genuine honor and at least to be part of the first issue of this paper. And I sincerely appreciate what the journal intends to do, because I believe that the journal, the existence of what the conversation that the journal intends to push is one that signals that there's an intersection between fashion, law, technology across Africa. And it's interesting that that's beginning to get the needed attention that we hope that it would continue to have. My paper is titled Data Privacy and AI Governance in the African Digital Fashion Ecosystem. Basically, I'll be speaking about the regulatory frameworks for e-commerce, personalization, and consumer protection. Next slide, please. Yeah. Let's start from what the real issue is. You would find, and as mentioned by the first speaker, the fashion industry in Africa is valued at about 31 billion, and this was as at 2021. And it's projected to even reach 50 billion by 2030. The continent has over 500 million active e-commerce users. And the fashion sector alone generates about 13.4 billion in online sales, and this is as at 2025. Africa has previously been derided as the dark continent, and now even UNESCO has said that the dark horse of the fashion industry, that Africa holds all the cards to become a leader in that sphere. This paper, I hope when you get to read it, is concerned about the governance dimension of that transformation that Africa is about to experience, or it's beginning to experience. Specifically, as the industry begins to get integrated with e-commerce, artificial intelligence, virtual reality, blockchain, and all these new developments, Africa's data privacy and AI governance frameworks are still predominantly OLO and nascent. Now, this paper focuses on a few things. One, I'll be speaking about the data privacy risk in fashion. You moved a little too fast, but my focus here, now let's talk about what the African digital fashion ecosystem entails. First, I'll be speaking on 4 major pillars, and you would find that you have the e-commerce platforms, you have fashion AI, you have VR, virtual reality, and CAD technologies, and you have blockchain. All of these 4 elements have contributed to what we see. These are the strong pillars of what we call the digital fashion ecosystem as of today. You have platforms like Jumia, Shopify, Anchor, and newly launched Efiong, I don't know if I pronounced that correctly, Stitches Africa. All of this are connecting African designers and tailors to global audiences. For fashion AI, you have tech solutions that are beginning to use AI to analyze social media images and predict specific trends per regions. Adegoke particularly has a machine learning recommendation engine that stitches and a machine learning recommendation engine. And then you have Stitches Africa with their AI generating digital measurement for bespoke tailoring. You would find that all of this have very serious implications or elements of data privacy in them. For time, please, let's move to the next slide. So let me know. Now, I would move to digitalization. What are the risks and reward for this? The rewards for digital transformation is real, and we've seen this across all sectors all over the world. E-commerce particularly has democratized access to market, particularly for the fashion industry in Nigeria, where 90% of them are SME-based. AI-driven personalization also has improved customer experience and brand efficiency. Virtual reality, reducing to a great deal product waste. You have blockchain. All of this have serious risk. And one of them being data privacy violations is probably I believe is the strongest risk that comes with this development. You would find that this e-commerce platforms require consumers to provide them with some very personal information. You have names, addresses, payment details, body measurements, and your browsing history. These are things that are very particular to you. And in the African context, where many consumers are beginning to get more digitized and become more aware of this, there's a deficiency in the digital literacy. Not many people understand what they are consenting to. So this sort of creates a significant vulnerability for consumers. Then you also have, as another risk, you have algorithmic biases. AI systems are trained based on specific data sets that reflect the culture, race, and economic biases of their creators. This is another issue you would find. I don't know how much experience you've had, but I'm sure you've had some experience dealing with some of these things. They are not exactly tailored towards Africa. All of this have significant risk for Africans. Now, we'll move to cyber threats, cybersecurity threats, particularly in VR environments. That is another big issue. You have, because they collect biometric information, biometric data, this exposes users to great risk. Another issue is the exploitation of the African cultural data. AI systems being not trained on so much on our own data sets, they have a way of exploiting some of this African motifs, these textiles, these things that are original to us. Now, let's talk about what the current regulatory framework looks like. Next slide, please. Hello, can you hear me? Okay, thank you. Yeah, at the moment, this is what the regulatory framework looks like. In Africa, at the continental level, you have the AU Malabo Convention on Cybersecurity and Personal Data Protection. This is the primary instrument across Africa. This was adopted in 2014, and it took about almost a decade after before it got ratified by only 15 out of 55 AU members. This tells you what you need to know about the practical reach of this framework. Nigeria, South Africa, Kenya, and Egypt are probably the largest digital fashion markets in Africa. They are not even state parties to this convention. You would also find that this convention predates the emergence or the popularity or use of AI, virtual reality, and blockchain. So this convention doesn't even recognize them as challenges because it didn't, they were not in contemplation at the time these frameworks were made. Then you have the AU AI Continental Strategy. This is a fairly more contemporary instrument because it was made in 2024, in July 2024. It's not binding, very aspirational, and its focus is largely on agriculture, healthcare, public services, not so much reference to fashion or e-commerce. So again, you would see that deficiency in the recognition of fashion as an industry that needs serious regulatory frameworks to exist. Then let's narrow it down to Nigeria. The most significant legislation on this is the Nigeria's Data Privacy Act of 2023. Now, Section 37 of that act does something that is pretty interesting. It restricts the exclusive use of automated decision-making for significant effects on data subjects. This particular section and this provision has serious implication on AI pricing and personalization in fashion. The NDPC, which is the regulatory authority created by that act, has demonstrated significant enforcement ambition. This most visibly was seen in February this year with its investigation into Temu, the giant e-commerce platform, where it alleged that Temu unlawfully processed the data of 12.7 million Nigerians or Nigerian users. So I'll move again to another regulatory framework that exists in Africa, which is South Africa's POPIA. That's the act there. And I would say that this is probably the strongest regulation on this subject in Africa. Recently, the information regulator there, which is the agency in charge of that over there, fined Meta a whopping 220 million for breaches that they found to the act. This particular act in South Africa, why I say that it's pretty innovative is it has provisions on AI governance, and that's something that we haven't seen so much of across the continent. And I hope that conversations like this would further increase those efforts and make things change across the board. What are the gaps that I've seen in the regulation? One, you do not have a fashion-specific data governance rule. And that is an incredible problem. There's no jurisdiction that has enacted provisions specifically governing data privacy or data practices in fashion, e-commerce, AI trend setting, or VR fitting environment. We don't have anything that is very much tailored to that. Again, another gap that has been observed is the capacity of enforcement or regulatory authorities is a bit, not even a bit, it's quite narrow. The laws that exist even on paper are not so much enforced. And this creates some incentive for non-compliance, because really, if nobody is checking you or nobody is enforcing any of the existing rules, it gives you the liberty to do whatever you wish. Another concern or another gap that has been seen is the harmonization across Africa is still very limited. You would find that only 15 ratifications for the Malabo Convention. You would find cross-border enforcement of consumer rights are still very nascent and almost impossible. Yes, another critical point that I would say is none of the existing frameworks addresses cultural heritage data. And I think this is very important for our textile industry. You would find that our fashion is not about one person. It's almost cultural. So if we do not have existing laws, or if we don't have laws to guide this creates the room for exploitation. Next slide, please. Can you hear me? Yes. For me, I would propose, and that's what I've done in this paper, to propose a few recommendations. I call them Afrocentric policy recommendations that I think that are specifically tailored towards Africa and would help to achieve what we seek. One of them is that the AU needs to develop a model African fashion data governance framework. This would be a sector-specific protocol to the existing Malabo Convention that would establish very binding and minimum standards for fashion, e-commerce, fashion, AI, VR, and blockchain applications in that sector. This should incorporate communal rights, recognizing fashion data as something of collective identity. Another recommendation from this paper is that Africa data protection authorities should introduce mandatory transparency and bias auditing to the algorithms for fashion AI systems. This would be drawing from the existing EU AI Act. And I think that if we try to sort of replicate that here, it would also help our industry. Another one that I would say is we need to improve consumer digital literacy across Africa. There's a wide gap in that area. Most people do not even know so much about their data rights or the privileges that they have. And this is something that I think we need to improve on. Another recommendation from the paper is that governments need to do more in training even practitioners in this fair, build capacity even for the enforcers of fashion law or the existing protocols. So in conclusion, I believe that Africa's digital fashion ecosystem stands currently at a very pivotal juncture. And Africa, using UNESCO's words, has and holds all the cards to becoming the next world's fashion leader. But the governance architecture that exists at the moment would need to be greatly improved on. I do not believe that the path forward is to transpose European or American regulatory paradigms onto African realities, because Africa is a completely different environment. I think that the approach, or the best approach, would be to develop original Afrocentric response, one that reflects the continent's specific vulnerabilities and values. I believe that the continent is poised to lead global fashion and must lead that in its own terms, or in its own terms. So that would be all, and I thank you again for the opportunity to present my paper, and yeah, thank you.
Thank you very much, Dapo. That was a rich and very timely contribution. And it was very important to add this digital governance lens into the journal this year. So thank you so much for depicting that perfectly. We are now going to listen to our fourth paper presentation. So Dapo was number 3. And we're going to listen to our fourth paper, which is titled Harmonizing the African Fashion Market, a Policy Framework for ADR, so Alternative Dispute Resolution, in cross-border trade under the AFCFTA. So this paper takes us into the dispute resolution dimension of fashion law. It argues that if cross-border African fashion trade is too deep and meaningfully under the AFCFTA, then accessible and commercially realistic mechanisms for resolving disputes must develop alongside liberalization itself, particularly for SMEs, so small, medium-sized enterprise, and creative businesses. So I am pleased to invite Blessing Adegoke to present paper number 4.
Good day, everyone. Please, can you hear me?
Yes.
Okay. Good day, everyone. I am Blessing Adegoke. I am an associate member of Nigerian Institute of Chartered Arbitrator and also a law student. Today, I am honored to present my research paper on the topic Harmonizing the African Fashion Market, a Policy Framework for ADR in Cross-Border Trade under the African Continental Free Trade Agreement. Oh, I've not shared my screen.
Yeah, we don't see any screen.
Okay, let me set it up now.
Hello, Blessing.
Please, I'm trying to set up to share my screen.
Okay, okay.
Please, can you see my screen now?
Yes, we can see it.
Yes,
I can see it.
we can.
Thank you very much. Okay, I'll start by talking about the background of my research. The African Continental Free Trade Agreement represents one of the most ambitious economy integration projects in the contemporary international trade law. The African Continental Free Trade Agreement was adopted in 2018, but it was entered in force in 2019 with the objective of creating a single continental market for goods and services across the 54 African countries. The African fashion market is driven by small, medium enterprises, informal traders, and independent creatives who often operate without formal contract safeguards. The African Continental Free Trade Agreement dispute settlement protocol mechanism is largely state-to-state in orientation and does not provide direct remedies for private commercial actors engaged in cross-border fashion trade. The mechanism set up by the African Continental Free Trade is private individuals cannot bring a matter before them. It is only a state that can bring, so it is like a state versus state. So for creative in the fashion industry to bring an action before the settlement protocol mechanism, they have to like go through their government, and which is very stressful because majority of the government are not interested in disputes that has to do with fashion law. The absence of a harmonized, efficient, and industry-sensitive dispute resolution framework undermines the broader objective of the African Continental Free Trade Agreement. I'll move on to the next slide. The problem statement and research gap, I'll title it a legal vacuum in fashion trade dispute. Majority of the trade disputes in the fashion industry involve overlapping issues of IP infringement, contract breaches, counterfeiting, and others. The African Continental Free Trade Agreement existing settlement of dispute mechanism is generic and insufficiently tailored to the fashion sector, unique commercial and cultural dimensions. Also, litigations across multiple African jurisdictions is expensive, slow, and inaccessible, particularly for small, medium fashion enterprises. Also, there is no dedicated ADR framework tailored for fashion trade disputes operating within the African Continental Free Trade. The African fashion market thrives on creative partnerships across designers, manufacturers, stylists, and retailers. When the nature of litigation will destroy the relational and reputational of the commercial relationship they depend on. The African fashion market thrives based on reputation, confidentiality, and when this relationship is being destroyed, it will not allow for intertrade in the African fashion market. The core agreement and thesis of my paper. The fragmented nature of African fashion trade demands a dedicated ADR mechanism anchored within the African Continental Free Trade Agreement framework. One that bridges the traditional divides, protect cultural hybrid, and ensure efficient, cost-effective cross-border dispute resolution. Basically, private individuals in the fashion industry does not have a standing to bring an action before the mechanism, the settlement of dispute mechanism set up by AFTA. The only option available to them is to go to court, and basically different rules apply in courts in different courts or jurisdiction. So this proposed framework of my paper is going to be suited to the economic realities and structural characteristics of the fashion industry. To the main arguments of my paper. ADRL as the preferred mechanism justifying the framework. Basically, the after settlement of dispute protocol set up by the AFTA was modeled according to the World Trade Organization model. And basically, World Trade Organization model deals with sectors like oil, gas, agriculture. So, and the fact that it was modeled with the World Trade Organization does not fit into the fashion industry, because the fashion industry is seasonal. It's most fashion business thrive on season, because when the season of a particular but when the particular period of a trend is over, the the aggrieved parties will not be able to get remedies. So in this slide, I made a comparison between the protocol set up by AFTA and the proposed ADR framework. The primary actors for the AFTA protocol is state by state. So basically, it's only the states that can bring an action before the AFTA. So if as a creative in the fashion industry, you are aggrieved, you have to lobby with your state, your government to bring a case. And most times, the government are really not interested in disputes that has to do with fashion. But under the proposed ADR framework, private individuals can now bring actions for infringement of their rights and the likes. Also, like I said earlier, the fashion industry is seasonal. So resulting to based on the AFTA protocol, the settlement of dispute leads to years due to the procedural delays, unlike the proposed ADR framework, which can be aligned based on the season of the market. And also there can also be virtual meetings for the ADR framework. Then to the expertise. Basically, the AFTA protocol is being headed by trade disputes diplomats, but having a proposed ADR framework, we enable the African fashion market to have their own specialized fashion law and IP specialists. Then in terms of access, it is more accessible for small business owners, creative and even informal traders in the fashion industry. Also, in terms of confidentiality, the proceedings of the AFTA protocol are public, unlike the ADR mechanism that allows for private proceedings, because most of African fashion market deals with confidentiality, and when the terms of the nitty-gritty of the brand is exposed, the brand is going to suffer like a kind of low in sales. So ADR supports non-disclosure agreements and likes, because when you bring a case either before the AFTA protocol or in court for litigation, it is no longer private again. The decision, everything becomes public, unlike ADR who protects the brand secrets. Also, in terms of trade relationship, um basically litigation and the AFTA protocol advances this win-lose situation, but ADR advances win-win both parties win like on a equal average, unlike the litigation and the HAFTA protocol that allows for the win and lose situation. The key findings from my research: after existing dispute settlement protocol is modeled on World Trade Organization framework and does not accommodate the commercial realities of the fashion sector. I've explained that earlier. Mediation is
sorry to cut in, but I do need to keep us closely to time, so you can go towards your recommendation and your conclusion. When you're done with this, you can go towards your conclusion later, okay?
All right, thank you, ma'am.
You're welcome.
Okay. Mediation is one of the first-tier ADR mechanisms for fashion trade disputes, given its flexibility, confidentiality, and relationship-preserving qualities. Also, arbitration provides the necessary binding enforceability for high-value cross-border fashion trade disputes. Now to my conclusion. This article has demonstrated that the African fashion market requires a dedicated sector-specific ADR framework integrated within the AFTA dispute resolution architecture. This framework proposed bridges the gap between the commercial dynamism of African fashion trade and the legal infrastructure needed to sustain it. The significance of this research: these proposed frameworks has practical implications for fashion traders, public makers, arbitration institutes, and intellectual property bodies across the internet. I will end this session with this. Harmonizing dispute resolution in African fashion trade is not merely a legal necessity. It is a strategic imperative for the successful realization of African continental economic vision. Thank you.
Thank you so much, Blessing. It was a very practical and important intervention. And when we read your paper, we thought that it was very important to add it to the journal because we need to know about the dispute resolution dimension of fashion law, especially in African market. So thank you so much for your presentation.
Thank you, ma'am.
I think I will introduce paper number 5. Bernice, let me know if Praise is back. And if I should take her or...
No, he's not here. It's not here.
Okay. Someone need to close the mic. Okay, so now we're gonna hear about our 5th and final paper for session number 1, titled Intellectual Property and the Informal Fashion Economy in Africa, Structural Misalignment and Regulatory Reform. So this paper closes the session unless Praise come earlier, but this paper actually brings us back to one of the core structural realities of African fashion, which is the tension between legal system that presume documentation, that presume registration and traceability, and fashion economies that often operate through speed and formality and low margin entrepreneurship. So it is a sharp and competing argument for regulatory alignment rather than blame. So please welcome Mercy Ola to present paper 5.
Good morning, everyone. Can you hear me?
Yes.
Okay. So I'm going to share my slide now. Can you confirm that you can see my slide?
Yes, we can see your slide.
Okay.
Yes, we can.
Okay, so good morning, everyone. My name is Miss Oluwanifemi Ola. I'm a practicing lawyer in Nigeria, and the topic of my presentation today is intellectual property and the informal fashion economy in Africa, the structural misalignments and the regulatory reform.
We can't see your slide anymore.
And you're muted, Mercy.
Okay, can you see my slide now?
Yeah, you can start over.
Okay, so the topic for my presentation today is intellectual property and the informal fashion economy in Africa, the structural misalignment and the regulatory framework reform rather. So I'm sorry, I'm trying to move to the next slide. Okay. Oh, I'm so sorry. Please give me a few seconds to rectify this.
That's okay.
Okay, can you see my slide now?
Yes.
Okay, I'm so sorry for that. So, oh, um,
I think you just need to touch your
okay,
like your keyboard, or yeah, you can stay like this. It's fine. It's fine.
okay. Let me just go like this. So my abstract, the African fashion is now has broken into the global industry, global space because of the commercial force, and is now shaping the global aesthetics and encouraging youth entrepreneurship. UNESCO has noted that annually the fashion space generates about 15 billion US dollars in exports, with a capacity to triple if it is adequately supported. However, it is important to note that there are still some major setbacks in the African fashion space, which includes the rapid copying, weak enforcement, limited commercial control, and even the fact that creators do not wish to protect their works within the available legal frameworks. And the African fashion, might think or ask that, is it actually suffering because there are no intellectual property laws that are available? The real problem is that these existing laws, they were not designed for formal business systems, while most of the fashion industry in Africa, they operate informally. So there's a mismatch, there's a friction between the legal framework and the market in itself. And that's why this paper argues for a hybrid regulatory model that protects creativity without destroying the informal ecosystem that largely sustains the economy. So the formal I have about six key findings in my paper, in my presentation, and the first is the formal legal framework. So in most African countries, you find out that there are actually available IP laws, intellectual property laws that protect the fashion industry. Amongst them are the Copyright Act, Industrial Design Laws, Trademark Act, patent laws, and even the regional frameworks that support cross-border protection. Those are the HOE, PI, and ARIPO. So in doing my analysis, I drew them from Nigeria, South Africa, and Kenya. So my second key finding is the informal reality of African fashion. The African fashion market, they are largely driven by micro, small, or even medium enterprises. You see tailoring clusters, you see minimal documentation. These people, they do not do record keeping, and if they do, they are very inconsistent. That is because of the sphere of that at which they operate in their business. So let's just say that they lack some sort of good corporate structuring of their businesses. So, and the market is largely dominated by short product cycles. You see designs coming, every week, every month. And that is our reality in the African fashion space. And also the low margin distribution. So still talking about the informal reality of the African fashion, according to HILO, over 85% of employment in Africa mirrors this reality. In other words, this space, the industry in itself has supported employment and has contributed significantly to the economy of the continent. Designers often do not register their work. Most of them operate as micro enterprises without formal documentation, like I said. Some of them are not really educated. Some of them just pursue this fashion thing as a passion and, to showcase their creativity and, they're able to make ends meet from it. So the informality supports job and creativity, but it is also a reality that copying has been enabled by this informality. And the regional systems there, they are good, but they are not supporting small designers. And which this brings me to my third key finding, talking about the informality as both a constraint and a creative engine. This segment is is showing that the informality in this sector should not only be viewed as a defect, because it enables low entry barriers, youth participation, speed, trend responsiveness, and even employment, which has, significantly contributed to the economy of the nations, the African nations, and, pushing these people that ordinarily would not be in the international space. They're globally recognized and they are doing very well. So the first key finding is talking about the informational problem, that it is not a wholesome barrier to weak legal protection. So many would say that these creatives, they do not know that they have existing intellectual property rights available to them. But the question is, even with awareness campaigns, would they still bother to register? Would they still seek to protect their works? The truth is, awareness campaign is not sufficient because the process for filing filing the protection or filing their this trademark, copyright, design, patent, they are very expensive. They are very strenuous. I'm a lawyer. When I see this SME come to me that they want to trademark, and I tell them the rudiments, they're like discouraged, they're frustrated because they do not even have the capital to, embrace these very formal, long, expensive procedures. And when you also hear that, there are renewal applications, they just say, you know what, don't worry. The market is fast-paced. How would you expect them to protect the work that in 1 month is not there anymore? So these are barriers. We also have enforcement barriers such as slow and costly litigation. In the event of intellectual property infringement and they want to go to court, there are some major setbacks like the slow and costly litigation, delayed enforcement, the burden to prove their case is very high. The standard is very high because, like I mentioned, they are SMEs. They operate very informally, low record keeping, low documentation, and all of that. And meanwhile, the court system is very strict. They adhere to the available IP laws, and those rudiments are very, very strict and formal. So the fifth key finding is talking about the real problem, which is the institutional fit. So these various IP laws in Africa, they were adopted from non-African legal parlance. And these systems, they operate very formally. You see them registered businesses, documented authorship, registered assignments, centralized administrative capacity, and predictable judicial enforcement. So when these legal frameworks that were developed in high-ranking developed countries and formalist economies, they are now transplanted into a predominantly informal setting, such as the African market. Without a structural adaptation, it is inevitable that there will be enforcement gaps and some form of friction or a mismatch, as we see in this our current dispensation. My last key finding is talking about the legal policy and practical implications. And because of all I have said, it is now important that our laws, our intellectual property laws, they must be shaped to fit African market realities. These courts and regulators, they need to act, to make small creators get faster, cheaper, and simpler protection mechanisms. And also, policies should also support gradual formalization, not to outrightly ostracize these informal businesses that largely contribute to the African fashion market. And the last year is a stronger protection that can improve their growth, investment, and gain designers' confidence. So to the last part of my presentation today, I call it the hybrid regulatory model. So this is the recommendation section, and I target the SME-friendly approach, a more way to bring both the formal businesses and the informal businesses that largely dominate the space. And the first pillar is talking about the simplified protection. So there should be a consideration for short-term automatic or unregistered design right for new collections, because the market is fast-paced. So there should be a consideration for that. Also, reduced filing fees for these SMEs. They should also be considered, and collective registration through fashion associations, especially in Nigeria, where I'm from. There are associations, and there can be a form of collaboration with these associations to effect collective registration. So the second pillar is institutional strengthening. Like in cases of intellectual property disputes, instead of approaching the general civil court to make their claims, there could be some sort of creation of a small claims IP tribunal. In other words, a tribunal that is particularly created to deal with, to address IP disputes. And there could be some sort of fast-tracking mechanisms around it, just to aid and aid the faster determination of IP disputes. Then with this, the court or the tribunal would have simpler evidentiary rules for creative industries, because the current reality is that most of them operate informally. So instead of shutting them out and making the standard very high for them to come in, most of them, they do not get the actual redress. It's just like justice is shut out. They're shut out of attaining justice. So there could be some form of simpler evidentiary rules, just like in a customary court, where the evidence acts in Nigeria is the standard is a bit reduced for them. So we could have that same thing in this IP tribunal. So there could also be some form of digital filing and low-cost disputes platforms, where filing and all of these transactions can be done digitally and efficiently with minimum cost. So my last pillar here is gradual integration of informal actors. There could be some form of incentive-based formalization. Here, regulators and the government and necessary stakeholders should consider supporting these enterprises that are likely contributing to the economy of the country, and also alleviating employment and postulating creativity by support, giving them tax incentive, export access, and procurement benefits. These would actually encourage them. It will accommodate them, support them, just so that they feel some form of safety in the laws of the country. So to the last, in conclusion, Africa does not need more legal symbolism. It needs legal systems that actually work for its creators. Thank you very much for listening. Thank you to the African Fashion Law Institute for having me. Thank you very much.
Thank you so much, Marcy. That was a strong paper to close the session's presentation segment. And I really liked your quote at the end, which is actually very true. It's not just about symbolism. I think Praise is not here yet. Let me check. No. Okay. So thank you to all 4 presenters for a very strong first session. What we have heard this morning across these papers is a serious engagement with the foundation of African fashion law, how the field should be conceptualized, how its institutions function, where legal doctrine succeeds, where it fails, and what kinds of reforms will make the field more coherent and more usable in practice. We will now move into the Q&A portion of the session. So if you would like to ask a question, you're welcome to either raise your hand or place your question in the chat. If you are directing your question to a particular presenter, please feel free to indicate that. Otherwise, I may also invite one or more presenters to respond where the question speaks across multiple papers. So I'll give you just a brief moment for questions to come in. I do have a question for Mercy. I'll begin with one question from the chair. So Mercy, based on the notes that I have, yes. So your paper resists both blaming designers and romanticizing informality. How do you think policymakers can strike that balance in practice without pushing small actors further outside the legal system? And I have another question. I think, Mercy, you can think about it. I have another question for Bernice. Your paper speaks very clearly to legal pluralism and formality. So in your view, what is the biggest risk if African fashion law is theorized only through formal statutes and institutions? What do you think is the bigger risk for you? Maybe we can start with you, Marcy.
Can you hear me?
Yeah.
You know, in my recommendation, I made mention of the hybrid approach where I spoke about the accommodation of SMEs in the formalization, the legal framework that we have presently. And that's where I spoke about the fast track small claims courts, IP tribunals. And in that tribunal, I also made mention of simpler evidentiary rules for creative industries. So it's a way of accommodating them because we do know that these enterprises are pretty small, they're SMEs, they have little to no documentation. I'll make an instance now. If you, in the case of IP infringement in Nigeria, there are procedures and there are some certain things to prove, and it would include documentation, your certificates of registration and all of that these small businesses do not have. So when I spoke about simpler evidentiary rules and standard, that's what I meant. Just like in the customary courts, the Evidence Act is a little bit, is not suspended or shut out, but then standard is dropped a bit. So I kind of made like a comparison that we could have that in this small claims court, and they are also accommodated. I also spoke about having a reduced filing fees or some sort of short-term automatic or registered design right for new collections because the market is fast-paced, and these SMEs, they do not have the capital base or the financial buoyancy to actually make recurrent protections or filings for these new collections. And that's why I said I mentioned reduced filing fees and short-term automatic or registered design rights for these new collections. I hope I answered the question.
Yeah. Yes, you did. Thank you, Marcy.
Thank you.
Thank you. Bernice, are you able to answer now? I also see the question in the chat. Yeah, you can go ahead.
Yeah, okay. So like I mentioned during my presentation, I think that if we focus on just the formalization of fashion law and not looking at the informal aspect, there would be a very big gap. And I talked about the very fact that the current IP framework is it is focused on a singular actor, basically. But if you look at our contribution to the global fashion market, particularly Africa, Africa is home to over 2,000 different cultures, right? So it means that we are producing our creativity as a community. We have cultural heritages that can be monetized. It means that we would not be looking at the way that it was interpreted to us and it was documented. We are not the people who documented all of those things. We just know that this particular thing is peculiar to a particular people. So when we do not take into cognizance these informalities that exist, we'll be leaving out a chunk of, a lot of the creativity of the African market. So it's one of the reasons why we have to look at it not just from a formal lens, but also from an informal lens. There's also the very fact that we would now only be focusing on the big brands and the people who can afford lawyers, and we would not be able to focus on people who cannot afford, who do not have the understanding that is required for protection. There's also the very fact that when you think about our fashion education system, it is also an apprenticeship. You see that people learn from people. There's no formalized standard of education for fashion. It's something that you pass down to another. Now, when you tend to say, okay, we're going to say that everybody who would have fashion skill would only go through a formal route, we'll be leaving out a bulk of people who obviously over time they've acquired skill set, not through formal learning also. So I feel like we have to take into cognizance everything, the unique aspect, the concept of the unique context of Africa to be able to come up with policies that are favorable to us, and laws that are, very focused on the way that we operate, basically. So I hope that answers your question.
Yeah, definitely. I do agree with that too. I think it's harder when you have so many regions inside of one continent to try to coordinate everything. So yeah, I twins.
Yeah.
Thank you, Bernice. I think we have a question in the chat. Eliojo is asking, there is a real concern that African countries are simply copying Western AI frameworks without asking whether they actually work for us. What would an AI governance model that is truly built for African fashion actually look like? I think this question can be asked to Dapo. Dapo, do you think you're able to answer that? Is Dapo still with us? If not, someone else can answer for him if you have an answer for that. Bernice, I know you mentioned AI a little bit in your paper. Do you think you can enlighten us a little bit with this question?
Okay, just looking at the question that he asked, I actually really think that it also ties to what I've been saying since about the collective, basically. When you think about ownership, right now there's no framework talking about who owns what under the AI model. We don't know what is sufficient modification or sufficient contribution to getting the required outcome. So once you put in a prompt in an AI system and it comes up with a solution, how do we vary what was the measure of your input to it? So basically, I think that for us as Africans, right, for us to have an AI governance framework that's tailored to African fashion or protects us really, it has to talk about collective ownership of our work. Like, I mean, it's what I've been saying since that the current IP framework does not exactly really look at our communal ownership. So if we're going to have an an AI framework rather, that sort of talks about or reflects the African realities, I think we will have to be looking at collective ownership. And then also us owning our own data too. That's, one of the problems that we have. How do we gather our own? How do we create our own data sets? Those are the gaps that exist. And I think that any AI framework should be able to answer those questions.
Yeah, definitely. It's unfortunate that Dapo is not here anymore because there was this paper. I think he would have added a lot of insight on this question, but it's fine. We are at the end of our Q&A session. So thank you very much to everyone who asked question and who answered. And thank you again to our presenters for a thoughtful and intellectually serious first session. Session one has made one thing very clear, is that African fashion law is not speculative. It is already a real field of inquiry with clear doctrinal challenges, institutional tensions, and regional stakes. And the strength of the scholarship we have heard this morning reflects just how necessary this field has become. So we will now move into session number 2, and I will ask you to, while you're listening to all the presentation, to have some question in mind so we can have an even more interesting Q&A session at the end of session 2. Grace, do you want should I start session 2 right away, or you want us to do a little break, or I can...
I think we can start right away because a lot of the presenters have been on the call. So.
Okay, good. So we're session number 2. Welcome to session number 2 now. Session number 2 is titled Sustainability, Technology, and Emerging Regulatory Frontiers. If session 1 helped us define the field and its structural foundations, session 2 pushes us into some of the most pressing frontiers now shaping African fashion law and policy. So we can talk about waste governance, secondhand clothing, algorithmic power, extractive supply chains, and imitation in consumer markets. So what is especially striking about this second group of papers that we're going to hear about is that they all deal in different ways with the afterlives and outer edges of fashion. So not only how garments, brands, or inputs are created, but how responsibility is distributed once harm, exploitation, opacity, or technological disruption enters the picture. So these 5 papers that we'll hear about ask difficult and necessary questions. Who bears responsibility when textile waste is exported into African markets under the language of trade or reuse? How should the law distinguish between secondhand circulation and actual waste? What does ethical AI governance look like in an African fashion ecosystem, like we were wondering? What does responsible sourcing require when fashion and luxury supply chains depend on opaque and conflict-linked extraction? And finally, how should the law respond to dupes, fakes, and the consumer demand that sustains imitation? So while this session is framed around sustainability and technology, it is also very much about accountability across borders, accountability across supply chains, accountability in digital systems, and accountability in the consumer and market choices that shape the fashion industry from within. It is also a session that shows the breadth of African fashion law as a field. So here, fashion law is not limited to garments or trademarks. It reaches into environmental law, human rights, data governance, trade classification, extractive regulation, platform power, and consumer behavior. So that breadth is one of the reasons this journal matters. It creates space for scholarship that reflects the real complexity of the industry rather than reducing it to one legal lens. As with the first session, we will hear 10 minutes presentation and then move into a moderated Q&A. With that, let us begin section number 2. Our first session number 2 paper is titled Fast Fashion and the Transboundary Movement of Textile Waste, the Regulatory Gap in Africa. And this paper is forceful and unapologetically clear in its framing. It treats textile waste flows into Africa not as an unfortunate byproduct, but as a structural and legal injustice. It draws also on the Bamako Convention, Article 24 of the African Charter, and extended producer responsibility models to argue for a more sovereign and accountable regulatory response. So please welcome Jennifer Ikpe to present paper 6.
Hello, good afternoon, everyone. Can we hear me okay?
Yes.
Okay. I'm coming. I want to ensure that everyone can see my screen and it is the presentation, the PowerPoint presentation that's being correctly displayed before I begin. Okay.
Yes,
So
we can.
can we still see me and see the presentation on the screen?
Yes, and we can hear you very well too.
Thank you so much. All right. Good afternoon, everyone. Good afternoon, yes. I imagined I will be doing this in the afternoon. Okay, so it's still morning in my location. I would just say good afternoon. Good afternoon, everyone. My name is Jennifer Ike. I'm from Nigeria. I currently work as a paralegal at Starlist Partners in Warri, Delta State in Nigeria. Can we see me? I can't see me.
Yeah, we can see you. It's fine.
Okay. Okay. So the work which I will be presenting today is titled Fast Fashion and the Transboundary Movement of Textile Waste, the Regulatory Gap in Africa and the Way Forward. Okay. So before I begin, I'd like to juggle our minds, like paint a scenario and imagery for us to relate with. So imagine this. You cook, right? You cook your meals or you have someone cook your meals. And then you're done with cooking. And all the, the byproducts, the waste that comes out of this, you gather everything and you take it to the trash bin of your next door neighbor. I mean, what does that say about you? I don't know. I think that would be inherently wrong, naturally against natural justice. It's not something you would do intentionally. So this is actually the entire concept of this article. So what I'm trying to say with this piece that I wrote is that the European the fashion industry in Europe has for a long time made Africa a place where they could easily avoid the responsibility of dealing with the waste that comes out of the fashion industry. And this is not fair. This is against everything naturally good. I mean, conscience will tell you this. So yes, I will be moving the slides now. Yes, so the reality matrix, we have the material, and the systemic truth is that this is hazardous. It may not look harmful at first. I mean, it comes in different forms and shapes. We call it charity, we call it trade, we call it different names. But the bitter truth is that all of this is systematically aggregating to something that is environmentally harmful to the ecosystem. Now, in Africa today, we have this global local paradox of the creative industry sector. Everyone is moving at a very high speed creatively and in the fashion space. So imagine how this movements that we're having is being affected by the reality that we actually face as a continent. We still have these environmental problems that we did not create ourselves. Are we together? I just want to know everyone can hear me.
Yes, it's great.
Okay, thank you so much. So the cost of handling this waste is something that should not be borne by someone who did not create it. I don't know if that makes sense to anyone. It's just, I don't know. It sounds like common sense to me. I mean, I did something. I should take care of my mess. I should take care of whatever I created, whatever byproduct comes out of the complete and the entire production process. So it is not an afterthought. I finish cooking. The waste that is being generated from the entire cooking process is not something that is accidental. That is what I am saying. I should deal with it. I should take it out. I shouldn't put my trash in the bin of my next door neighbor. And European, businesses, companies that are in the fashion industry shouldn't have to do that to our continent. It sounds like we're having colonialism all over again, but this time is waste colonialism. I can't see it any other way. That is what it is. So, and I am an advocate for, human rights, yes. And this is a clear human rights violation. Article 24 of the African Charter, it provides for the right to a clean and safe environment. Where is the clean and safe environment if we keep having, all of these landfills, degradation, microplastic in our water, because the waterways get clogged by these very byproducts and the production process that I've spoken about. So it's really disheartening. Like, it breaks your heart when you actually do the field research. You would you would actually cry. I know it's a lot of I'm very passionate about the environment. It is a course that I took. I wrote my final year project on environmental law, and it is something that I have done an in-depth research into. So when this topic came up for me to write about, it just flowed, and I just saw how everything is intertwined. There is no break. It is all a full process that we need to deal with. Okay. So there is something else I like to say. The fact that currently in Africa, with the way textile waste has been so, should I say, incorporated into the entire African system, we now have names that we give it. So in Nigeria, we call it Africa, secondhand clothing. I mean, I am not denying the fact that there is a viable economic, I want to say prowess, gain in that area. Yes, people do make money from selling secondhand clothing. People use secondhand clothing, it is good. What I am saying is that there is a regulatory gap and it needs to be addressed. This is the law of the entire piece that I am trying to talk about. There is a regulatory gap in Africa, and we cannot leave it unchecked. The silence is deafening. The silence is what has led to a lot of, abuse of the environment, basically. Yes, that is what I am saying. I'm not saying completely take out secondhand clothing. There is no way that Africa will survive without secondhand clothing. I say this in all honesty. So, but what I need for this space to create is a proper structure, a clear structure that would enable Africa to stand in its sovereignty, that will enable Africa to still carry itself with self-respect. Because all I see is colonialism. I'm sorry. Oh, no, I'm not sorry. I'm unapologetic about it, actually. So we need to have regulatory frameworks. We need to have clear demarcations, lines that cannot be crossed, should not be crossed. That is what I am a firm advocate of. So this is a number of the things that I've been talking about the landfills, the waterways are clogged. We have microplastics that destroy our main source of livelihood. I'm from Delta State, and we fish a lot. That is like the major thing. I eat fish a lot. I do not like meat, not because meat is bad, just because I grew up here, and that is the predominant meal that we have. Now imagine how dangerous this textile waste over stuffing. Like, it's a lot, actually. We can't eat fish no more. And even if we do, it's on the high side because we hardly get to catch enough fish like we used to. And why? Because an industry decided that Africa was only going to be a dumping site. Yeah, actually. Okay. So I'm saying that waste is not accidental. It is a structural outcome. Yes, that is the entire thing I'm saying. And we should have regulatory frameworks that will address it so as not to make for legal silence that will enable injustice. So we have under environmental law a principle called the polluter pay principle. And it's very, very interesting because when you look at people who produce, the garment and all of that, they are not owning up. They're not wanting to take responsibility for the production process. And that's sad because Africa cannot continue to be a recipient of that. So how do we move forward? We need legal frameworks, and the legal tools already exist. So first of all, I took a look at the Bamako Convention, and I saw that, okay, they actually provide for they ban the importation of hazardous waste. So the idea I had was, okay, so if we can find a way to prove and make it into the Bamako Convention that textile waste, especially those parts of textile waste that become a problem eventually, because nobody can actually tell that it will become a problem. But at the end of the day, it is a problem. So if we can deduce and find a way to incorporate this into the Bamako Convention, then we would have, legal teeth to address the issue. Then I also looked at Article 24. So looking at this entire problem as a human rights violation and not just vibes, because yes, there is a lot of vibe around this issue, but it is a clear human rights violation. And if you come under Article 24, this will be epic. That's what I'll say. Then lastly, I took a look at South Africa's extended producer responsibility scheme. So what they're practically saying is that the polluter should pay. Like if you're bringing this textile waste into Africa, you should pay. It's like tax, but that is not tax. But you should pay because Africa is not equipped to handle the infrastructural development that has to go into all of the process for handling textile waste. Like anyone can talk about recycling, upcycling, but really the reason why we recycle a lot in Africa is because we're being forced to. Like we have no choice, really. Like we have to make use of what we have to get the best that we can. And that is how every African everywhere have always lived. Wherever they step into a place, they make the most of whatever they have. It's, I don't know, it's inherent. Well, I think every human being is like that, but then I see it a lot in Africans, and that's why they thrive wherever they are. They're able to take something small and multiply it and make it beautiful. It's just something that we do without even like thinking about it. So I've spoken about the Bamako Convention, the human rights violation, and then if you can see what I see right now, I'm saying that the Extended Producer Responsibility Scheme will enable foreign manufacturers to bear the financial cost of these textile waste. So even if you're going to export the textile waste to Africa, you will bear the financial costs. Yes. And I think when everyone starts to see that they will take responsibility for the waste that they will generate less waste or not at all. But that is impossible. Waste must be generated. It is a product of life. Like, you must generate waste. So I would use the toilet, sorry to say that, because I am alive. So a living organism will have that feature. That means waste is inevitable. If you know waste is inevitable, you have to create structures around it that will make it to be okay and safe for your next door neighbor, for the reasonable man. Yes. So there is the idea that when we demand these corporations to be accountable, it will stifle foreign investment and trade. No, I don't think that. I think that when you allow dumping, that is not investment. When you keep accountability and the funding within Africa, you are helping to preserve the self-respect, the sovereignty of Africa. Really, I don't think we're being rated in the world as it is. That's why anything can come in. You see a bill, and 60% of that bill is trash. You can't use those clothing. I know for a fact, because I have been in those spaces and I have grown up in those spaces, and I know what it is like to try to want to feed your family with second-hand clothing system, and then what you have is rags. Okay, so yeah, this is the last page of the slide, and I'm saying that Africa is not a landfill. It's time to close the legal loopholes and enforce the legal frameworks and return the costs to the creator. We need to stop silence. We need to stop all of the quiet that goes around it. Everyone is just being careful. We don't want to walk on eggshells, AFCTA this. I am not saying that that is not real. It is. But we need clearer legal structures that will enable us to preserve our person as Africa, our sovereignty. Thank you very much.
Thank you so much, Jennifer. It was a very compelling and important presentation. And it brings forward an issue that goes well beyond fashion regulation, engaging directly with environmental law, human rights law, and questions of transnational responsibility. So thank you so much for your presentation. Our seventh paper.
For the opportunity.
You're welcome. Our seventh paper is titled Waste or Wealth: Reframing the Legality of Secondhand Clothing in East Africa. So what I appreciate about this paper is that it resists an easy binary. Rather than treating secondhand clothing simply as either circular opportunity or waste dumping, it argues that the legal problem lies in the absence of clear categories and coherent classifications. It is a thoughtful paper about evidence, regulatory language, and responsibility. So I am pleased to invite Mitchell Namawa Kakai to present paper number 7.
Thank you, Massala. Please confirm that you can hear me and see me.
Yeah, we can hear it.
Okay. Just give me a moment to present my Uh, can you see my screen?
Yes.
No. So, good afternoon, everyone. My name is Michelle Kakai, and I work here in Kenya. And I think I'll just get straight to it because I think my paper is a continuation of the conversation that has already been started by Jennifer on the concept of whether secondhand clothing is essentially waste or wealth. And I think Jennifer focused more on the waste perspective. So for this paper, we try to look at both aspects. So I'll go directly to the core argument of the paper, in the sense that when we talk about secondhand clothing, especially in East Africa, and I see that we've spoken about the different names that we give secondhand clothing. So in East Africa, we have a name for it. It's called mitumba. So in East Africa, the conversation is normally divided into two in terms of what has been mentioned as West colonialism, while the other side is the circular economy success story that is there. So my paper essentially argues that when we bring it down to this binary, we miss the core point. The fact that the contradiction between these two narratives is not primarily the empirical perspective of which data should we go for, but rather it is a conceptual problem, right? And it exists because there's no shared legal framework capable of distinguishing between a garment that is reusable, a garment that is repairable, a garment that can be downcycled into industrial inputs, and a garment that is genuinely waste. And until we are able to resolve this definitional question, then no amount of data that we get is going to be able to arbitrate this debate that we are having. So essentially, the task of fashion law, according to this paper, is not to define whether secondhand clothing is in fact harmful or is an opportunity. It is to build the regulatory architecture that makes this distinction legally meaningful. So we'll get into it. Now, where does the confusion come from? Because the most visible symptom is the striking divergence in the waste estimates that we see. You find that industry surveys allow me to also just mention that this data is sampled mostly from Kenya and Uganda, still trying to get the data from across DRC and the rest of East Africa. So when you look at industry surveys, such as the 2025 report of the Mitumba Consortium Association of Kenya and the Institute for Economic Affairs in East Africa, so they put the waste estimate in secondhand clothing to be 1 to 2% of each imported bale. But then when you move to trader reported figures for low-grade streams and investigative reporting across the region, you frequently find that we have figures such as 20 to 50% of each bale that we import has a lot of waste. And then we further have other institutions such as EU sorting centers, so in this case the IVL, Swedish Environmental Research Institute, that found that bales that are coming from rigorous EU sorting centers arrive in Kenya with a near zero unusable content. So for them, waste is almost near zero. So then the issue becomes, how can one product then generate such wildly different numbers? And the answer lies in three perspectives. The first one is the fact that, and this is the central this is the central foundation of the whole paper, that different studies are measuring different phenomena, or rather that they're measuring different waste categories. So they are measuring waste on arrival, others are measuring waste that becomes unsellable at first market entry, and others are also measuring waste that only emerges years later when the garment is discarded. And the other thing that we could also perhaps look at is the fact that, of course, different actors have strong political incentives to favor particular estimates. Because, for example, for an exporter, if I give the data that I have low waste figures, then it downgrades the assumption that there is waste colonialism. But for environmental advocates who are trying to ask for there to be more regulation on this, they would also benefit from higher estimates. And then the third point that now feeds into the whole conversation also in this paper is the fact that the HS code, which is the classification that is used within the World Trade Organization system and also within the East African treaty customs in terms of categorizing imports when they're coming into the country. So this HS code is also very completely quality blind. It will record the volumes and the values of import of second-hand clothing imports, but it will not tell you about the durability of the second-hand clothes. It will not tell you about the fiber composition or the grade. So the data infrastructure in and of itself cannot answer the question that we are asking, which is how much of second-hand clothing is in fact waste that is being brought into the global south. So we get into what do we have under the law. Now, I've just sampled 3 perspectives. This is not all that is there. Of course, we have the Bamako Convention that has been mentioned, but I'm just mentioning these 3 just as an example and because they affect every different perspectives. Yeah. So we have the Basel Convention on Waste, which then lists worn clothing as generally non-hazardous. And under the directive, waste is defined by the intent to discard, and all separately collected textiles are legally classified as waste until they have been sorted or reused. Then we have the EU Waste framework. Now, this is a very important one. And before we even get to the EU directive, what you notice is that by the definition of the Basel Convention on what classifies as worn clothing and textiles, textiles are treated as secondary material rather than waste shipments that require strict control, which is precisely why the trade then has expanded so freely without any quality oversight. And then we come to the EU Waste framework. So, and this is important because there has been a new directive that has been brought about by the EU. That has been brought by the EU in 2025. So under this new directive, waste is defined similarly to the Basel Convention, but it also introduces a mandatory extended producer responsibility scheme, which creates a legal paradox whereby what is legally discarded under the EU law is then a commodity under East African law. And what happens is that even when it comes back to East African law, when it comes to East African law and it's sorted and there's waste, then it changes from commodity to waste again. And therefore, as Jennifer has also shown in her paper, the environmental cost of that life cycle from commodity to waste shifts entirely on African communities and informal waste systems within East Africa and other regions of Africa. And then the third regime that, or rather the legal aspect that I had mentioned before is the HS code, which is essentially a code that is used by the World Customs Organization. Can you hear me?
Yeah, we can hear you now. We had a little issue earlier, but now it's good.
Okay. I hope you didn't lose me.
No, not too much. We were following you.
Okay, thank you. So then I was mentioning the last classification, which is the HS code, which unfortunately does not encode garment durability, fiber composition, or all these aspects that would help in terms of determining how we're going to classify secondhand clothing. So let's now look at these categories that we're talking about. What exactly are they? So the first operational category of this clothes. So when you see, as you can see from the slides, there's a bale, there's a huge bale. So when these clothes are imported, they normally comes in bales like this, huge bales, and that's where the word mitumba originates. Mitumba is a Swahili word to mean a huge bale or a huge gathering of things. So The first section is waste on arrival. So these are items that are essentially unfit for any use the moment they enter the country. And evidence from the IVL study, which is the one that I was talking about from the Swedish Research Institute, suggests that this is close to zero when sorting at origin is done well, or rather is done rigorously. Then the second category of waste is what we call unsellable at first sale, which means that these products are technically wearable, but due to the specific market that they're getting into, they cannot be used, right? An example is this. When you walk around some streets in Nairobi, you'll find that part of the secondhand clothing that is being sold is winter coats. But in Nairobi, it's almost always very warm, except in June. And even in June, it's like 15 degrees, 14 degrees is the least amount of temperature that you'll find. So the question would be, why is someone buying a winter coat in Nairobi? At the end of the day, you see, this is not waste. Essentially, it's not waste, really. It's technically wearable, but it's not suitable for that specific market. And then we have the third category, which is the end of life disposal, which is that these are secondhand clothes that have been worn for a long period of time, but ultimately discarded due to the fact that there is no recycling infrastructure that is capable of redirecting these clothes. So the critical legal point is that current law treats all these categories identical, and that is the core regulatory failure. And I mean, having spoken about how this is how secondhand clothing can contribute to waste, there's also the economic reality of it. I don't want to get into it so much because of time, but just to give some basis for it is that we see that so many countries are considering banning secondhand clothing, but for countries such as Kenya, where we have over 2 million people who are employed in the mitumba sector, we have so many people, 40% of the population in Kenya, due to poverty, can only afford these secondhand clothes. These are factors that the government considers when deciding that we're not going to impose a complete ban. But we've seen countries such as Rwanda. So Rwanda, under the AGOA agreement with the US, Rwanda banned the importation of secondhand clothing, and that has, of course, had its impact on the economy. And I mean, also the US retaliated in terms of some of the non-trade tariff barriers that it had accorded Rwanda and matters such as that. And we also saw recently that Zimbabwe is also considering imposing a ban on secondhand clothing. So to ban or not to ban is also a conversation that is happening right now in terms of, you know, how exactly do we regulate secondhand clothing waste. So essentially the key finding of this whole paper is that opportunity and harm are not mutually exclusive, in that the regulatory era, sorry, I keep losing my, oh, sorry. Can you hear me?
Yes.
Can you hear me?
Yes, we can hear you.
Okay, sorry. I lost my network for a minute there. So essentially, to summarize it all, is that in reality, the mitumba trade simultaneously creates significant economic value and generates environmental externalities at the same time. So these things can be true at the same time. And therefore, the task of law is not to pick a side, it's to build a framework that will then safeguard the legitimate circular value while also identifying and financing the cost of the actual waste. And that brings us to the recommendations that are there. As I mentioned, if this waste is classified, then we solve so many problems. And these are things that are already being put into place, or rather are being discussed in terms of, for example, UNEP's 2025 Circularity and Used Textile Trade Project. It's a project that is being done in Nairobi, and there are also Basel Convention discussions that are ongoing. in essence, it would be to categorize waste in the ways that is on the screen. So we would first of all have, instead of treating all imported use textiles as a single category, we will distinguish between reusable apparel, repairable or repurposable garments, downcyclable textile inputs such as the ones that are used for rugs, insulation materials, etc. And then we also have textile waste now, the main category that would be excluded, which is soiled or contaminated. So we find that for the first 3 tiers, it would be permitted, but under appropriate conditions. And the 4th tier would be rejected at the port of entry. So that's the first recommendation. Now, the second recommendation is that rather than relying on stakeholder testimony, East African states should require randomized bail audits at ports of entry, port of entry quality reporting as a condition for customs clearing, and national textile flow mapping from import through to disposal. What this will do is that it will generate defensible data and end the methodological standoff that we have seen at the start, where some say it's 1 to 2% of the waste, and while others say it's only 40%. Yes. And then now the third recommendation, which this one I acknowledge that it would be quite an administrative burden on states, but it would be something worth considering, which is that governments should advocate for reform of this HS code 6309, which would then introduce these granular subclassifications based on, say, for example, fiber composition, the grade and quality of the tires that I had mentioned before. And then the 4th one is shipment level traceability, which would require exporters to declare grade distributions before shipment. So if there's documentation this documentation is linked to customs inspection systems at entry points. And this is something that has also been done in the European Union, whereby what happens is that the EU grants a digital product passport. And this also comes in the conversation with AI and digital mapping. So it's a system that would be interconnected. And then the last one, which I think it has also been mentioned, is extended producer responsibility financing, which would be structured to follow the product basis, so that these contributions that are being given by the extended producer responsibility companies and then linked to the destinations of textiles flows. So they should not be simply collected at origin, which would mean that, for example, if we have waste that is coming from the EU and it's coming into Kenya, and this company is paying for the waste in the EU, that would mean the money still remains in the EU and the environmental cost is still transported to Africa. So we would have the EPR systems being set up in a way that the money that is financed through these EPR systems then comes back to the global south to help with the waste, managing the waste. So essentially, in summary, those were the recommendations that are there. Of course, there are many implications to this, given that we have, for the trade classifications that I've mentioned, they need reform at the international level. So this would be a question of not just domestic regulations that are being reformed, but also at the international level. And then also we have at the policy level, East African governments would have to come together for there to be regional harmonization, because one of the issues within trade markets is the issue of fragmentation of laws, and harmonization would really help in ensuring everything works out well. And then lastly, the practical considerations are also the fact that we would have to invest in sorting hub infrastructure, given that we've seen this happening in Ghana and in Kenya, and not just investing in the second-hand clothing imports and exports, but also in these sorting hubs, and also finding a way to protect the livelihoods at the same time. So conclusively, I'd say that we cannot reduce the conversation of second-hand clothing to either whether it's dumping or a development success story, because we see that there's evidence for both. And whoever is the piper that pays will be the one that determines the tune that will be there, whether or not it's going to benefit either sides of this story. So then the future is to look at a regulatory architecture that makes this distinction legally intelligible and also economically accountable. Thank you so much. That is all from my end.
Thank you very much, Michelle. That was nuanced, rigorous, and extremely useful. I think it really helps move the conversation. So after what we had with Jennifer, it helps move the conversation beyond the usual binaries and toward a more structured and legally grounded understanding of this issue. So thank you very much for your presentation. Yeah. Our eighth paper, she's not here, but our eighth paper titled AI Aesthetics and Agency, a Social Policy Framework for Ethical AI Governance in African Fashion Ecosystems, is authored by Anita Uzana Kongabe, who unfortunately could not be with us today due to a prior commitment. The paper offers a forward-looking analysis of AI as an emerging infrastructure in fashion, with a particular focus on data governance, algorithmic visibility, and cultural sovereignty within African fashion systems. So Anita, if you're joining us asynchronously, we're grateful for your contribution. So let's go ahead with our ninth paper. Our ninth paper is titled Regulating Nigeria's Stones, an Appraisal of Nigeria's Extractive Legal Framework and Global Supply Chain Ethics. This article expands the scope of fashion law in a particular valuable way by taking us into the extractive side of fashion and luxury supply chains. It asks what ethical style sourcing actually requires when gemstones are tied to informality, child labor, environmental harm, and conflict-linked governance failures. I am pleased to invite Olusegun Abayomi to present paper 9.
Hello, everyone. Thank you, Kélicia. That was a very astute explanation of the paper. I don't know if I should still even continue. Thank you. I appreciate also the editorial team. Thank you for letting me get here, and the non-editorial team of the Institute, especially the always wonderful Ms. Asein. My paper, so to speak, is it visible?
You haven't started sharing.
Okay. It's visible, is it?
Yes, it is now.
All right. Well, this is more of is what I would call an exploratory essay into the legal regime for precious stones and metals and general items of that category in Nigeria. We, in this essay, so to speak, I talk about other attendant issues and incidences in this industry, and then perhaps a way forward for a more globally attuned brand or distributor. Now the estimates of what we have as a country within underneath our soil is, by some modest estimate, what 700 billion in. I do not know how many kilotons of how they measure it, although it is not as much as our petroleum wealth. It is still in explorable amounts, and some people are taking advantage of this. regardless of that, or maybe because of that, it is only a minute fraction that it contributes to our global, our national gross domestic product. And it requires some overhaul in light of current situations Nigeria finds herself in with budget deficits and mounting insecurity in both life and economic potential. Well, I will examine the legal, environmental, and in a little way, the ethical dimensions of Nigeria's gemstone industry. Okay, as I have mentioned before, we have a lot of natural resources in Nigeria. There is gold, there is apart from these I've mentioned on written, there are a lot more that is mined in small and medium scale. Now there is this term coined by European sociologists about the resource cost, where countries that are bountifully endowed with natural resources that exploit those resources do not, for structural issues, do not allow those resources become a net benefit. Examples are like Libya, Venezuela, Nigeria. Now, the framework, the way it works in our local industries, people, because of the cost, and I think I prepared a detailed explanation of that in the article. The cost of creating getting a license is far and above the normal man's ability. It is but people have an obligation, to work, to mine. So people that have this in their that have mined all their lives in their families, they're not going to come up with 25 million for some mining license. They will mine anyway. And this now asks the question of where is what is legal and what is illegal when it comes to this kind of mining. But a large amount of it is done by small, artisanal small-scale miners. Okay, the statutory regime currently that centers this to be booming industry is first of all heralded by the Constitution, which vests all mineral resources in the federal government, but it is more controlled by the Ministry of, I think, Solid Minerals, administered by Minister of Solid Minerals, and they're empowered by the Minerals and Mining Act 2007, among other legislations like the National Extraction and Transparency Act, I think 2007 also. I didn't really go into that here. They have the remit to decide regulations for the mining industry and give permits, licenses, and all other such matters. But where there is a poor regime, like a lot falls through the cracks from different things that I will explore later. It gives birth to things like environmental toxicity. A recent study showed lead poisoning in Oshun River, which is a UNESCO heritage site, which in an ideal world would be a protected place, but instead is suffering from lead poisoning from from its own natural resource. And this is very reminiscent of 2010 lead poisoning case in Zamfara. Now, what happened there was it was a traditional thing, but the men used to go out to mine and they bring back the stones and the women will break the stones because that's how you separate the stones from the less precious stones. And as they did that in the home, there was cross-contamination, and children being the weakest of all, they suffered the most. There were over 2,000 children affected with lead poisoning, and at least 160 of them died. Broadly, there were no systematic repercussions from that, unfortunately. These are the issues. Further, there is the human capital crisis, which is a very fancy way of saying child labor. Child labor is unfortunately very prevalent in industries like this, in places like this that have little to no political will from the executive or security agencies. So life just goes on there, and you see children as young as 6-year-olds just carrying pans on work sites. Definitely dangerous to their health, but as a broad problem, it affects society. How much more can such a child give when they are working from 6 years of age in a lead or gaseous environment? But however, the Child Rights Act has been adopted, which prohibits this kind of thing. The enforcement, however, is still very questionable. I'm not aware of any broad legal pronouncements on the matter. And the Mineral Mining Act is still caught up in an ideal world where there is no child labor, and it does not legislate for that at all. But there have to be changes. And in order to, if a brand or an exporter that wants to be compliant with foreign best practices, such as the EU Corporate Sustainability Due Diligence Directive and the OECD Due Diligence Directive for garment and footwear professionals, I believe. In order to be compliant with those, there are checklists that one must pass through. And one of it is to ensure protection of human rights, which sourcing from child labor infected plants would come in position to. So it is worth studying or looking into. Now, another aspect to this question is the argument for improving our local supply chains in order to benefit from our own resources. So we do not fall into the same trap of removing resources like crude oil to go refine elsewhere. We have to improve and mechanize the systems that help exploitation in a sensible way. We have to develop local industries that do all the cutting, polishing, finishing, and through proper regulation and stakeholder consultation. Yet another aspect to this is the rampant insecurity issues, which can also be traced to the exploitation of minerals in largely northern Nigeria. There have been stories, verified, non-verified, but largely popular stories about foreign actors, like Chinese most of the time, paying bandits money in order to get their illegally mined products out. Now, none of this money gets to the federal government, and it is practically used to fund terrorism against the Republic. Now, between that and a man that cannot afford a license, who is doing the illegality there? And is there a line that draws the two? That's a question for the legislators whenever they edit the Mineral Minings Act to consider, because it offers a punishment of 5 years in prison for illegal mining. Now, that is more a broader question. A future in brand, a more compliant individual would look to do these kinds of frameworks in order to get their supply chain like fit and proper. It would help for and with investment and especially sustainable sustainability qualifications. So there are the OECD due diligence guidance, the EU conflict minerals regulations. These are European laws by and large, but they are very, very advisable best practices to live by or to legislate by. For our more local industry, it is my recommendation that the artisanal mining is brought into the picture and considered like the main status. It needs to be formalized. So the policymakers have to meet the common man at his level of cost and meet him with regulation in a way that still allows them control and enforce laws in this so the country doesn't lose and chaos is not allowed to run rampant. And due to the environmental issues that mining is associated with, community health provision should be top of the list of considerations. Since the oil spills of the Niger Delta, it has been the running theme where host communities suffer for the exploitation of their own resources. So it's in order to get to the next step, we have to learn some of these lessons. And another recommendation is to mandatorily, like in Europe, mandatorily enforce human rights and bring about the end of child labor in every form, child and slave labor. And also for indigenous beneficiation hubs, which is just a fancy way of saying indigenous mineral processing hubs, similar to the SEZ zone, that's in it's French, done by the Congolese government, where they create kind of reserves for miners, where everything is controlled by the state. Although that particular program, the success of it remains to be seen because the miners just decided to go back to where they were before. So I think it was a consequence of not also meeting demand in the miner for making policy decision, which I believe is very important. We are at a precipice where we like it or not, and it remains for the industry, for the exporter, for the buyer, for the miner himself to be more intelligent and forward thinking about what to expect from precious metals and how it will be taken in the future in the light of sustainable practices being the norm. So we will see where Nigeria gets. Thank you very much for listening.
Thank you so much, Olusegun. That was a strong and important intervention on a topic that is often left outside mainstream fashionable discussion. So thank you.
Thank you.
Our 10th and final paper of the symposium is titled Muses, Dupes, and Fakes, the necessity of bespoke frameworks regulating imitation in apparel and textiles. This paper closes the symposium in a very accessible but analytically serious way. It takes on one of the most familiar and commercially visible tension in fashion, where the line sits between inspiration, duplication, and counterfeit practice. It also combines comparative intellectual property analysis with consumer behavior data from Nigeria, which gives the paper a practical dimension that is especially valuable. So please welcome Avila Orakpo to present paper number 10.
Good afternoon, everyone. Good afternoon, everyone. I'm trying to share my screen now. Okay, please, can you see my screen? Please, can you hear me as well?
It's charging. It's loading. We can hear you and see you, and your screen is loading.
Okay, thank you. Thank you. My name is Havila Arapo, and I'm going to be.
Your screen is loading, so it's okay. Now we can see your presentation. Thank you, Akila.
Okay. My name is Havila, and I'm going to be presenting a paper titled Uses Dupes and Fakes, Necessity of Bespoke Frameworks for Regulating Imitation in Apparel and Textiles. So, an age-long demonstration is where the line between reference and replica is drawn. According to now, let's place it. One must avoid the difference, but that raises the question of whether there's truly originality in fashion. It has been argued that due to the cyclical nature of fashion, there's actually no original work, and every piece that is designed is taking inspiration from some other prior made work, which makes sense. And that then raises the question of whether designers should be allowed to protect their work, since their work is truly not original, so to speak. But the global apparel industry is valued at $1.84 trillion, and it accounted for 1.6% of the global GDP in 2025. So since fashion brings that much revenue to the world, why is it not as well protected as other creative fields like music or film? So this presentation is going to discuss forms of imitation, why imitation should be regulated, extant legal frameworks, challenges to regulation, role of consumer behavior, need for bespoke frameworks, and it will end with giving recommendations. In apparel and textiles, just like in the wider fashion industry, the actual existence of originality, as I earlier mentioned, is more debated upon. So there are three forms of imitation that are discussed in this work. The first is inspiration. This occurs when a designer takes one or more elements from the work of other designers and modifies them by infusing their own original ideas to create a unique piece rather than outrightly copying it or replicating it. And this is what the muse in the title represents. The second form of imitation is a dupe. It's short for duplicate and usually refers to a product made to look like a more expensive or high quality product. The third is a fake. This is a term that's often used to mean counterfeit, and it refers to a product which is made to appear genuine with the intent of defrauding purchasers or making them think that making them think that it is the product that it is imitating. And why should imitation be regulated? This can be traced to, or an explanation for this can be found in labor theory, which was propounded by John Locke. And he simply posited that individuals are entitled to ownership rights over property that they have obtained or produced with their labor. Hence, when applying this to apparel and textiles, simply means that imitation of designs without the consent of the creators is a violation of the ownership rights which accrue to them by virtue of their labor, and it renders their efforts wasted. There are different legal frameworks regulating imitation. However, in Nigeria, while the fashion industry is estimated to be between 2.5 is valued at between 2.5 to 6 billion annually. And though Nigerians are estimated to spend as much on clothing as they do on rent, almost as much on clothing as they do on rent, there's no bespoke framework necessarily regulating apparel and textiles or the fashion industry in general. And imitation can be regulated with the already existing intellectual property frameworks, one of which is copyright. However, the issue with copyright is that, for one, due to the limitations, it cannot regulate mass-produced textiles because there's a limit of number of copies that can be made of a good that can be regulated under copyright. And secondly, it only protects the aesthetic features of apparel and textiles, not functional features like cuts or things like that. So it only protects like the design, patterns, illustrations, and similar things. Then regarding industrial designs, This can protect the 2 and 3-dimensional aspects of apparel and textiles that cannot be protected under copyright. And regarding trademarks, while this might not necessarily directly apply to the goods themselves, trademarks can protect the names of the designers, and it also is particularly useful for designers whose names form an intrinsic part of their designs, like Wanifuga. And then there's also the European Union. In the European Union, copyrights can protect apparel and clothing due to the theory of unity of arts, because this theory simply means that fashion designs are not regarded as this simply means that fashion designs are not regarded as separate kind of arts from artworks or any other thing which can be protected under copyright. So fashion designs are protected under copyright in the EU. And the EU also provides for designs and unregistered designs. Everybody that purchases 2 different ways. Under registered designs, the work can be protected for a specified amount of time without being disclosed. But under registered designs, it has to be disclosed initially, and then it can be protected for up to 3 years. But then if the designer wants that design to be registered, they would have to pursue it within 1 year after disclosure. And then the EU also protects traditional trademarks as well as non-traditional trademarks like colors and shapes, like the color of the red sole of Louis Vuitton Hills. Then United States of America, copyright system that is similar to that of Nigeria, which only protects the aesthetic aspects of work and not the functional aspects. And then they also have design patents. While in Nigeria, to register an industrial design, the examination is a formal examination, and they are not really looking into the qualities of the work itself. But a design patent is a substantive examination, and it's a more expensive process than getting an industrial design. But I think that it's better since it actually does examine whether the work is new, and it will help to also prevent imitation more since it's looking at it in depth. And then there's trademark and trade dress. Trade dress is basically product design, and it's talking about the whole general appearance of a product, like the feel, and that's protected under trade dress in the United States. Then there are challenges to regulate imitation. One challenge is the adequacy of legal, and this means that number one, there's no bespoke legal frameworks regulating imitation in fashion. Secondly, the frameworks don't provide for fashion. And other copyright acts, the Patents and Designs Act and Trademarks Act don't take into consideration the current realities of the digital world and similar things. And then there's also the registration process for IP rights. It's very bureaucratic and very formal, and it's not something that's easy for people to do. And additionally, people don't really have awareness of the fact that their IP rights need to be registered. And there's also the fact that a lot of designers, smaller designers, might not be able to afford it, might not be able to afford the registration process. And there's also the fact that there's no digital registries where people can just easily go and find all the work that has been registered to even know whether their work is imitating an already registered design. And then there's also affordability. A lot of people who purchase imitation products do so because they cannot afford the actual thing. So that comes in the ethical side of it, where it's like, so should poorer people not have good things? And then there's also the conversation on social media with Nigerian designers, where when someone complains about the price of their products, or says that the price of their product is not realistic to Nigerian reality, they're like, oh, you're not the target audience. So that's also something to take into consideration. Then non-commercial, this is actually legal, like counterfeits. So that's why it's more of a blurry area to navigate. And then there's also the fact that there's also that comes into consideration when you talk about people just making homes. So we saw people who make clothes for themselves, and it's like, okay, so if I can sew and I make maybe a copy of Vicky James' dress, but I'm not selling it, can Vicky James now sue me? So there's that as well. And then there's internet and digital age that encompasses fast fashion. It encompasses the use of designs in AI, because if AI, if a generative AI bot, for example, creates a picture of me in a Vicky James dress, is that in relation to her? And then there's also the gamification of fashion and just a lot of other things to take into consideration. And then there's the use of false indications of source that comes into the when in a situation like Nigerian textile industry, where Ankara materials that were imported from majorly China were labeled made in Nigeria, and these saved consumers. But then there's the role of consumers in fostering imitation. They cannot be supplied without demand. So this a survey was conducted among Nigerian adults, and they were asked to pick between purchasing a clothing item that was above their budget for buying the clothing item, purchasing a dupe and purchasing a counterfeit. And the findings showed that individuals over 45 were most vulnerable to purchase counterfeits, while individuals between 18 and 24 are most likely to purchase dupes. And there's the necessity of regulation. The first is to foster innovation and creativity, because imitation is a disincentive to creativity for designers. And then there's protection of brand reputation, because the lower quality or the imitation products might get consumers confused with the actual product, and then affect the reputation of that brand. And then there's protection of local industries, like how I earlier mentioned, industry. There's protection of smaller creators who might not necessarily have an established clientele or be able to withstand the the income loss from imitation. And then there's the prevention of loss of income. So recommendation is enactment of bespoke legislation regulating apparel and textiles and fashion industry in general, and also amending the existing intellectual property frameworks. And then there's the overhaul of IP registration process to make the IP registration process in Nigeria to make it cheaper and to make it more straightforward and more efficient as well. And then there's amendment of existing IP frameworks. There's creation of judicial precedents through institution of actions in court, because there's really a dearth of material that really shows what the opinion of the courts on imitation is. So as much as interior mechanisms are good, there's also the need to go to court to establish these principles as well. And there's the need for the institution of stricter penalties against manufacturers of dupes and counterfeits, the enactment of legislation prohibiting fast fashion, which is a huge offender when it comes to imitation of products. And then there's use of smart labels in apparel to verify whether a good is original or whether it's an imitation product. And then there's international cooperation among countries to fight imitation and to fight counterfeits, and to pay particular attention as well to regions where counterfeits or duplicate products come from. And then there's licensing agreements this will particularly be effective for high-end luxury brands who can then find manufacturers in the global south who are guilty of counterfeiting, so that at least they're not making a total loss. Thank you.
Thank you, Adila. A very fitting paper with which to close the presentation segment of the day. Thank you to all 5 presenters in session number 2. I think that what this session has shown very clearly is that the regulatory frontiers of African fashion now are already here. The questions are no longer abstract. They concern waste flows, platform governance, AI infrastructures. We talked about mineral sourcing, consumer conduct, and legal responsibility across multiple stages of value creation and value extraction. We will now move into the Q&A for session number 2. I think, Eleojo, are you taking the lead on that? Or you want me to continue? Okay, I don't hear
Yeah.
back.
Yeah, I think you can continue. You can
Okay.
continue.
Okay, so as before, you're welcome to raise your hand or place your question in the chat. If your question is directed to a particular presenter, please feel free to indicate that. Otherwise, I may just invite more than one speaker to respond where I see that some themes are overlapping. So we'll take a brief pause to gather questions. Okay, we have one already, yes. So Rejoice is asking, hello, Ms. Kakai. During your session, you mentioned about a circularity and used textile trade project in Nairobi. Please, can you shed more light on it? Michelle, this one is for you.
Can you hear me?
Yes. We can't hear you anymore. Michelle?
Yes.
Yeah.
Sorry.
I think Michelle's not able to answer right now. Maybe she'll join soon. I do have a question. If you have other question, you can share it in the chat, but I do have a question for Olusegun. Are you still here? I have a question. You connect Nigerian mining governance to global luxury due diligence pressures very effectively. Do you think external due diligence regimes can genuinely improve local condition, or do they risk simply excluding Nigerian producers from market without solving the deeper structural problem?
Well, I think they are at risk of doing exactly that if there is no grassroots change, if there is no political and legislative will to change things within first. The foreign and global best practices are more advisory. They are more ideals to aim towards. And whatever happens in Europe is, well, for their market. We have to locally look within ourselves, not just Nigeria, everywhere else that has to do, that deals in exploitation of their natural resources and exportation of those resources to get refined elsewhere. They have to make peace with themselves first before looking outside.
Mm-hmm.
I don't know if that answers your question.
Yeah. Okay. Thank you. Yes, it helps to
Thank you.
understand more. Michelle, are you able to answer the question that was asked in the chat? Okay, if not, I do have another question.
Can you hear me?
Oh yeah, I can hear you now. Yes.
Oh, sorry about that. If I remember well, the question was about the UNEP textile trade project, right?
Yes, it's written on the chat too, if you want me to reread or you
Ah,
can.
okay. Okay, so essentially the trade project I was talking about is circularity and used textile trade, a project that is being led by the UNEP Textile Initiative. So what essentially it tries to do is to tackle textile waste by promoting a shift from linear models of circularity in terms of take, make, and dispose to try and build circular sustainable systems. And one of the areas that they specialize on is how to make mitumba clothing secondhand clothing, which is normally called mitumba clothing in East Africa, how to make it more sustainable and how to ensure that both the economic benefits and the environmental consequences are sort of balanced. And what they do is that they have a circular design hub. They normally have data that they're collecting from from different stakeholders like universities, SMEs, and also government organizations. But they also do this in collaboration with not just in Kenya, but also different governments like the Swedish government and also most recently, I think the Ghanaian government. Let me share the link for the same on the chat. I think that will help make it a bit better.
Yes, definitely. Thank you so much, Michelle. Rejoice, I hope it answers your question. We have another question in the chat from Grace. Nigerian gemstones and minerals enter global luxury supply chains. Are Nigerian designers and artisans capturing any of that value, or is it leaving the country entirely? And then she had another question. What specific legal reform will most immediately strengthen Nigeria's position in the global luxury supply chain? I think the first one can be answered by...
I think I can take that.
Okay, great.
Grace's question about whether the results of this exploitation stays within. I don't know, did I get that correctly? Okay. Well, as far as this, in my opinion, as far as the extractive industry is concerned, the gains are very minute compared to what can be. The gains are very little and largely, I think, unrewarding. That's why there hasn't been enough eyes in that sector yet, despite the budget shortfalls that the nation is having across board. So I would say not enough, not yet, not unless those gaps are plugged. The people are cared for, the environment is replenished as they take. So as we iterate, as we get there, we will see more of that staying within. But it's also a broader conversation about the economical situation of the country. So I hope that answers your question, Grace. Thank you.
Thank you. Yeah, I hope it answered your question. Great, Grace. Do we have another one? I had one for Jennifer. Jennifer, are you here? Jennifer, your paper is very clear that legal silence has enabled the current injustice. So if you had to identify one legal move that would have the most immediate practical effect, would it be reinterpretation under Bamako, litigation through Article 24, or EPR reform at a national level?
Okay, thank you, Kélicia. I think that these three would have to work together. If you're asking me to choose one particular solution, well, it would not be accepted if we do not have a law that will back it up. So definitely the Bamako Convention needs to be reinterpreted to include the fact that EPR scheme should be accepted. So I don't know how I should separate the solutions because they are like intertwined, if you understand. Yeah, I think you do.
Well, no, I can understand. It's true that sometimes it's hard to only separate one and work with it. So it can make sense, yeah. Do we have another one? Yes, we have another question in the chat from Eleojo.
Oh, sorry, Kélicia, I don't think that the entire question that was asked by Grace was fully addressed by Abayomi.
Oh, you're right, because Grace had a second question. Yes, yes. So Grace's second question was, what specific legal reform will most immediately strengthen Nigeria's position in the global luxury supply chain? I think, who can answer that? Is it?
Sorry, please, can you come again?
Yeah, so it's also in the chat. Grace is asking, what specific legal reform will most immediately strengthen Nigeria's position in the global luxury supply chain?
Okay, I think first of all would be to address security, first of all, of lives and properties, and then focus on the next issue, which is human rights protection, strict human rights protection for children, for affected communities. And then in that order, we can start thinking of more economic advancements. But like, I think first we have to go that way. Is this more?
Okay, so I mean, what you said is right, and I totally agree. But since this is going to be included in a fashion law journal, it would be also nice to talk about it from an angle of intellectual property. So if we are looking at your context, right, that's gemstones and precious stone, I think that it would also be nice to introduce geographical indication laws that ensures that there are proper credits given to where this is sourced from, and also not just saying that it's sourced from there, but having enforcement capacity, right? Because one of the arguments against geographical indication is that you've said that I mean, this particular product emanates from a particular region, but how do we enforce our rights? So I think that looking at the gemstone industry, it will be important to have geographical indication laws that protect these precious stones and where they are sourced from.
I'm in full agreement with that, actually. I'll take that in cognizance with the rest of the paper. Thank you.
Good. So we have another question from Eleojo. She's asking, some argue that imitation drives innovation in fashion. Does a bespoke regulatory framework risk stifling the creative borrowing that has always defined the industry? Question for Avila.
Okay, that's a good question actually, because that was also what I thought as well when I was trying to write the paper. So the thing is, imitation does drive innovation in the fashion industry. Then again, there's a line that's quite blurry, and since law is an instrument of control, it is the responsibility of the law to then determine where that imitation is permissible, and when that imitation becomes copying. Because if imitation was totally right, then counterfeits and knockoffs wouldn't be wrong. Does that answer your question?
Eleojo, does it answer your question?
Yes, it does. Yes.
Okay, good. I don't think we have other question. Do we have other question? Oh. Okay, no. We don't have other questions. I have one question for Michelle, and then maybe we can close with that. Michelle, one of the strengths of your paper is that it shows the debate is often distorted by conceptual confusion. So in practical terms, what would be the most useful first reform for you? Would it be better bail audits, better trade coding, or legally recognized classification system?
Well, I think from from two angles. The most simple, fast, practical step would be better bail audits. And it would be the most simple because essentially it would entail importers just highlighting the categorizations of what is contained within their bills, and that being tied to custom clearance. So practically in terms of the most simple step, that is it. But I think practically in terms of what would help settle the system as a whole is to start from having a better sort of HS code identification for all these second-hand clothes imports. But the problem is that for us to be able to get a better harmonized system code, it's a long process of negotiations, not just domestically, but also between international organizations and most especially between countries. And as we've seen even with the recent MC14, it's very difficult for countries to come together to make a multilateral decision when it comes to issues of sustainability. It takes quite a long time. So practically the most simple step, better bail audits, but practically the best step that should start is better HS code systems. Yeah.
Okay, great. Thank you. Thank you, Michelle. That was very insightful. I don't think we have time for another question, unfortunately. What time is it? Yeah, we don't have time for another question for now. But I think that concludes, thank you, Michelle, for the last answer. That concludes the two session. Thank you very much for your presence, to everyone for the question, and thank you again to all our presenters across both sessions. So it has been a privilege to share this conversation today. The quality of the scholarship presented here confirms that African fashion law is not only emerging, it is maturing with real seriousness, range, and originality. So what we have heard today is rigorous, it's timely, and genuinely field-building work, because it's the beginning. That what we're doing is really new. On behalf of the journal, I also want to acknowledge the presenters for the depth of thought that you brought to your papers and to today's discussion. The symposium has shown exactly why this journal matters. It creates a space where African legal scholarship on fashion can be precise, can be ambitious, policy relevant, and intellectually confident on its own terms. So thank you all once again. I will now hand over to Eleojo Umushola for the publication announcement, closing remarks, and a vote of thanks.
Hello, everyone. Thank you so much, Kélicia, for the wonderful, wonderful session. We thoroughly enjoyed you moderating the session. And thank you to all our participants and everyone who put out time to attend this symposium and just listen and learn. We are deeply grateful. We appreciate you being here with us today and contributing to this conversation. To the authors of the journal, we are deeply grateful. Your work has enriched us. It has shown us that we are doing a very good work and there is so much more work for us to do. And I believe a lot of us have learned a thing or two or more from all the presenters have said today. We also want to especially appreciate Kélicia Massala. She's the managing editor of the journal. And right before this time, she has been doing so much work, trying to put everything together. And I know it's been a lot because it's a lot of work putting all these things together, but she has dedicated her time and made sure that today's symposium is a success. And I believe I speak for myself and everyone when I say that today has been a huge success, and we are anticipating further symposiums or further editions of the journal for us to learn more and possibly for other persons to also contribute to the journal. So thank you everyone for being here today. I think this is the end of today's symposium, and all presenters have spoken and everyone has given their side of the journal. So next week we'll also be having our summit, Pan-African Fashion Law and Policy Summit. So we are going to be having conversations about fashion law in Africa. We're going to be having fashion councils from different regions of Africa talk about fashion law, about policies, and it's going to be so enriching. It's going to be just like this, having people talk about fashion in different regions of Africa, which we've not heard before, and just being available to learn different things from different people that are experts in their fields and that have more knowledge about these things than us. So it's going to be on the 24th of next month, and the link is in our bio, Fashion Law Institute Africa Instagram. You can click on the link and register for the summit. I think with that, we've come to the end of today's session. I don't know if Ms. Bernice would like to say anything before we officially close today's session. Okay. I think that's all for today. So thank you everyone once more for joining us and for participating. Okay. Bye.